Uh, Good evening to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Mr. Arvind Akshan Nair, sir, and to all the participants in this fourth day of 10 days online national capacity building program for civil judges examination of Gujarat State Judiciary, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, sir, former Judge of Supreme Court of India, in collaboration with Gujarat High Court Advocates Association, which is a voluntary organization formed by Association of Advocates regularly and ordinarily practicing in the Gujarat High Court with the purpose to promote the professional goals, objects, and interests of advocate members in general, and is led by managing committee which shall have total 15 elected members. It holds legal seminars and study circles to keep the member advocates updated with the current legal developments and advocate care society, where today's session is all about overview of Constitution of India and legal maxims. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during this session. If you have any questions, please use the chat box or raise your hand. It is my privilege to introduce our esteemed dignitary, Mr. Arvind Darshan Nair, sir. Sir enrolled as an advocate with the Bar Council of Gujarat in June 2007 and commenced his legal career in the chambers of Mr. Harin P. Rawal, sir, former Additional Solicitor General of India, where Sir assisted in matters relating to indirect taxation, constitutional law, and civil law before the Honorable High Court of Gujarat. From 2009 to 2012, Sir independently handled cases across constitutional, criminal, civil, and indirect taxation laws. In 2012, Sir joined the Gujarat State Judicial Services and served as a civil judge and judicial magistrate first class at Nadiyar and Sankheda until 2016, adjudicating a broad spectrum of civil and criminal matters. Since returning to practice in July 2016, Sir have been regularly appearing before the High Court of Gujarat and various quasi judicial bodies, including the NCLT, CAT, NGT, CGIT, CDRC, and SCDRC, representing statutory bodies such as Employees Provident Fund Organization, Employees State Insurance Corporation, Central Pollution Control Board, and Gujarat Pollution Control Board. Sir also served as Special Public Prosecutor for CGST Rajkot Commissionerate from April 2022 to October 2023 and have represented the states of Andhra Pradesh and Telangana before the Honorable High Court of Gujarat. His practice further extends to arbitration matters, particularly under Arbitration and Conciliation Act 1996. Currently, Sir is empaneled with several government and statutory organizations, including EPFO, ESIC, CPCB, GPCB, Surat Urban Development Authority, Rajkot Municipal Corporation, and previously with the Gujarat State Legal Services Authority. We are deeply honored to have you with us today, sir. Over to you, sir.
First of all, I would like to thank all the participants over here, and I'm overwhelmed to attend this program. And first of all, best of luck to all the participants who are going to be future judges of our Gujarat judiciary. Now, coming to the topic which is assigned to me, I would be just giving you a broad spectrum of how the constitution works and what was the intention of the constitutional framers when they legislated this beautiful draft. For that, if you can, Ms. Kaur, if you can just share the screen, I can share you a PPT presentation which was prepared by me for the convenience of all. If you can, please.
Yes, sir.
No. Is it available? No?
Yes, sir, it is.
Yes. First of all, if we want to understand what was the intention of the Constituent Assembly when the Constitution was being framed, we need to understand what is the soul of this Constitution, or the basis, or the I would say the what was there in their mind when they were intending to frame this Constitution, and that is what we get from the preamble. For everyone's, before I go further, I would just want to read it so that everyone keeps in their mind that what the Constitution exactly intended and what is the basis. Many a times you would find there are certain provisions which are not so clear. You need to understand from the perspective of the framers of the Constitution, and accordingly, this was their intention. So I'm just reading it down. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens, mind these words, please: justice, social, economic, political, liberty of thoughts, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of individuals and the unity and integrity of the nation. Now, mark these words also. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. This is I would go to the extent of saying that this is the people of India have framed this Constitution and they have given it to themselves. That is how it was intended to be formulated. Now, today I'll be even referring to some beautiful words of Justice Rohington, who has said certain things about this Constitution. I'll just read it. Let every person remember that the Holy Book is the Constitution of India, and it is with this book in hand that the citizens of India march together as a nation, so that they may move forward in all spheres of human endeavor to achieve the great goals as set out by this Magna Carta, or Great Charter of India. Now, coming to the academic purpose, as as the audience, most of the audience are intending to appear in the judicial examination. First of all, I'll just give a broad spectrum of Constitution. The Constitution is divided into 22 parts, bearing 395 articles, 12 schedules, and that in the to start with, I'll just first of all introduce you all to Article 1, which gives our great nation the name India, that is Bharat, shall be the union of states, and the states and the territories thereof shall be specified in the first schedule. If you would go to first schedule, you will get the list of states which are there, the union territories specified in this first schedule, and other such territories. Here, the Constitution has used the word state at two different places in two different perspectives. One, the state which we understand as covered under the this first schedule. Next would be when we are hello.
Yes, sir.
Yes, okay. I'm audible, no?
Yes, sir. Yes, sir. You are audible.
Now, to understand that what does state mean in other perspective, in other part of the Constitution, we are supposed to see the definition of state in Article 12. With your permission, I'll just read it out. In this part, unless the context otherwise requires, the state includes the government and parliament of India, and the government and the legislature of each of the states, and all local, all or other authorities within the territory of India, or under the control of the government of India. Mind you, in the Constitution, the word state has been used in two perspectives. One in respect of state, which we in normal parlance understand as Gujrat, Maharashtra, Bihar, and all, and the state which is governing the which would go to mean that the government or the local authorities which are amenable to who have been conferred with the certain constitutional obligations under the constitution, who would be responsible to I would say this wise that देश को चलाने के लिए उनको responsibility दी गई है, the state and its machinery. Now, before going further, I'll just come back to the two provisions. Sorry, I would say the entire constitution is using two words which are very important in my understanding. One is citizen and another one is person. If you would see at various places, the constitution, this framers of the constitution have used these two words in different perspective, but they have, whether they are in they have been understood in the proper perspective or not is would depend on interpretation of every such provision as and when it comes before the court for interpretation. Now, before going further, just to elaborate the example of where the words person have been used and where the words citizen have been used, one must keep in mind person herein would even include a non-citizen or an alien also. So for that, Article 14, Article 20 and Article 21, if you would see, the Article 14 casts the duty upon the state. Here, please understand the word state. State herein means which has been defined in Article 12. The state shall not deny to any person equality before the law or equal protection of laws within the territory of India. This goes in conformity with the preamble which I just read out. If you would see the preamble, the first thing, that is justice, social, economic, political, to ensure that every equality is maintained. The duty has been casted upon the state. Here, if you would just uh, see the intent of Article 14, which has been made as a fundamental right of every person who is who is within the territories of India or outside the territories of India. Every person would have the right to claim equality before law when it is against a state action. Now, Article 20. Here also word person has been used. Mind it. I'll just read. Protection in respect of conviction for offense. No person shall be convicted of any offense except for violation of law in force at the time of commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offense. No person shall be prosecuted and punished for the same offense more than once. No person accused of any offense shall be compelled to be witnessed against himself. See, the protection which has been granted to a person under Article 20, mostly you would find its application in criminal jurisprudence. Whenever a person is facing a criminal trial or criminal prosecution, it is intended that no person can be punished for any act which was not an offense on that particular date. Retrospective applicability of uh, penal provisions have been prohibited by the constitution, time and again confirmed by various constitutional courts also. Now, Article 21, one of the most elaborated, I would say celebrated article of constitution, which has evolved substantially from 1950 till date. So it has such a beautiful words. You must just go through it. No person shall be deprived of his life or personal liberty except according to procedure established by law. It is conferring a right on every person as well as casting an obligation on the state machinery that no person's life or personal liberty should be affected without there being an established or the procedure established by law. So these articles in constitution are giving certain this which have been recognized as fundamental rights to every person. Now there is another criteria to whom the fundamental rights have been conferred. For that, now let us come to Article 15. If you would just see Article 15, prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The clause 1 casts a duty on the state. It says, the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. Number clause 2. No citizen shall on grounds only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access so and so, so and so. Now, same way, the provisions have been, this protection has been extended to citizens. Now, those who are going to appear in the exams, for them, please, Article 16, equal opportunity in matters of public employment. There shall be equality of opportunity for all citizens. Here, the word citizens have been used, intentionally used, in the matters relating to employment or employment to any office under the state. Again, no citizen shall on the ground of so and so, so and so, so and so shall be discriminated. Similarly, for the develop this protect this for public employment, the constitution has granted or safeguarded certain fundamental rights to every citizen. Now, Article 19, this is also mostly I would say uh, rather invoked, um, whose violation has been invoked before the honorable high courts and the supreme courts on the ground that the protection of the freedoms which have been granted under Article 19(1) have been violated. Let us see what are those freedoms. Protection of certain rights regarding freedom of speech, etc. All citizens shall have right to freedom of speech and expression, to assemble peacefully and without arms, to form association or union or other operatives, to move freely throughout the territory of India, to reside and settle in any part of territory of India, and to practice any profession or carry on any occupation, trade or business. Now let us see what restrictions have been imposed on these freedoms. Those we can find in clause 2 to clause 6. I'll just read clause 2. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as law imposes reasonable restrictions on the exercise of right conferred by the said subclause in the interest of sovereignty and integrity of India, the security of the state, friendly relation with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or uh, incitement to an offense. Uh, Even clause 3 would be relevant. Nothing in subclause B of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of so and so, so and so, reasonable restrictions. If you want to understand the contours of Article 19, the freedom and the reasonable restrictions, these are the two terminologies which have been used and to be made to be interpreted time and again, which have been interpreted by the Honorable Supreme Court. Now, then comes, as far as part 3 of the Constitution is concerned, in my opinion, these are the fundamental rights which one should always keep in mind. Now, coming to the next part, uh, I'll just take you all to one more article 50. All those civil judges, please. Article 50 states separation of judiciary from executive. We just now read Article 16, right? I'm sorry. One has to understand, on one side, the Constitution is granting equality or recognizing equality of opportunity in matters of public employment, and on the simultaneously Article 15, which is separating the judiciary from executive. I'll just read the words. The state shall take steps to separate the judiciary from executive in the public services of the state. That is why, if you would just see the advertisement which must have been published, it must have been published by the Honorable High Court of Gujrat. It, after a long drawn uh, application of mine by the Honorable Supreme Court, this power of, or I would say the jurisdiction to appoint the judges, has been taken over by the the high courts, or the have been conferred to the high courts, who are now exercising the entire procedure of appointing the civil judges, or be the district judges. Now, one more article before going further. I just wanted to point out part 4, one of the uh, highly debated part of the Constitution, which has time and again come under scrutiny when there has been claim of violation of fundamental rights as against the state's failure to discharge certain obligations which have been conferred, or rather imposed on the state, right? So this entire chapter, directive principles of state policy, though it cannot be enforced by court, but certain articles which have been taken shape into certain marvelous legislations, I'll just read out those. Article 39A, which says equal justice and free legal aid. If one is to appear, one is regularly practicing, he must be aware of Legal Services Authorities Act, and the state legal services authorities and the district legal service authorities who have been discharging their functions. I would go to an extent and say that those were the functions of state which are being discharged by these authorities, which are either which have been established with the aid of this Article 39A. One must always keep in mind when they are interpreting, or reading the provisions of Legal Services Authorities Act, what is the source of that particular legislation. Here, that is Article 39A, equal justice and free legal aid. The state shall secure that the operation of legal system promotes justice on the basis of equal opportunity, and shall in particular provide free legal aid, and by suitable legislation or schemes, or in any other way, to secure that opportunities by securing justice are not denied to any citizen by reason of economic or other disability. Now again, if we go back to the preamble, there also the intention which is carved out is just accessibility of justice to the lowest strata of the society. Now, Now let us come to part 4A, the fundamental duties. A difficult chapter uh, which was inserted in only in 1977 with a great hope that people would start uh, taking a responsibility on themselves and discharge their functions by keeping in mind these factors. And what are those fundamental duties which, though have been prescribed in the constitution, but very rarely been performed by the citizens of our country? It shall be the duty of every citizen of India to abide by constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideas which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render national service when called upon to do so. I doubt whether if it tomorrow anyone is called upon to perform this fundamental duty, how many would uh, be happy to join it? To promote harmony and spirit of common brotherhood amongst all people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of woman, to value the preserve the rich heritage of our composite culture, to protect and improve the natural environment and including forests, lakes, rivers, wildlife, and to have compassion for the living creatures, so and so forth. I would just point out one aspect. Uh, there, being a panel advocate for pollution control boards, what I have found is even the basis for creation of that particular statute, that is the Environment Protection Act, Wildlife Protection Act, and so forth. The, initially, the state was not so much keen into uh, further that particular cause, but only when the Honorable Supreme Court, by invoking the Article 21 and the principles laid down therein, have compelled the state. Here, when I say state, it includes central government as well as the state governments and uh, all the parliament and the state legislatures to to promulgate such kind of legislations. So, time and again, when the courts have interpreted the provisions of constitution, be it in any of the chapters, some fruitful results have come. Before going further, I'll just a highly debated article these days. I just wanted to point out, which may be helpful for your examinations also. Article 44, Uniform Civil Code for the Citizens. Highly talked, and in future we are hopeful that this article would be uh, implemented in its proper perspective. Which says the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Now, I just forgot one more aspect. Article 32, the remedies for enforcement of rights conferred by this part. This part would mean part 3, which provides for fundamental rights of every citizen as well as person. The moment there is any gross violation or breach of fundamental rights of an individual, the Constitution has given the remedy to approach the highest court of the land under Article 32, which have been which has been turned out to be of I would say this wise, that landmarks judgment have been rendered by the Honorable Supreme Court under Article 32 while interpreting mostly Article 21 of the Constitution of India. Now, as far as are your judicial examinations and all those parts are concerned, you must be going through all those articles for once. But in my understanding, you must be aware of chapter 5 in this. I'll move on. Before that, the high courts in the state, article article 214, under which provision the high courts have been constituted. You must be aware of that. Article 216, how it is to be constituted. Article 2117 refers to how the appointment of judges is to be made in the high court. Then article now article 226, this is an original jurisdiction conferred upon the every high court, which empowers them to deal with any issue which is brought before them concerning fundamental, constitutional, or any other legal purpose. The words like notwithstanding anything in Article 32. See, right now I just discussed on Article 32 the power, the jurisdiction of the Honorable Supreme Court to entertain a petition directly when it sees that there is a gross violation of fundamental rights. Keeping it aside, every high court have power throughout the territory in relation to which it exercises jurisdiction to issue any person or authority, including in appropriate case, any government within those territories, directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them. I hope everyone must have uh, be aware of what are these writs. Same way, if this is about the state legislature. Now, similarly, if Article 124 onwards is seen, the entire chapter pertaining to Union Judiciary, that means the Honorable Supreme Court. This also a prospective judge must be knowing that under which provision the Supreme Court has been constituted, how the judges are being appointed, what are their powers. Now, as far as jurisdiction of the Honorable Supreme Court is concerned, there are original jurisdiction also, appellate jurisdiction also, which have been provided in the Constitution. One original jurisdiction was Article 32, which is a unique in itself. Now, Article 131, if it's seen, original jurisdiction of Supreme Court, when can be invoked? Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the Government of India, one or more states, or between the Government of India and any state or states on one side and one or more other states on the other, or between two or more states, if and insofar as the dispute involves any question whether of law or fact on which the existence of extent of legal rights depend. There are certain provisos also, but I'll not read that. Now, what about the appellate jurisdiction of the Supreme Court? Article 132 gives Supreme Court the appellate jurisdiction against any order which has been passed, certain orders which have been passed by the Honorable High Court. But there is one restriction which has been imposed. If you want to invoke Article 132, the clause 3 of Article 132 has to be kept in mind, that unless the certificate is issued by the Honorable High Court, directly the appeal cannot be filed before the Honorable Supreme. That certificate is generally issued in such cases by the Honorable High Courts when the issue which they have decided is of such a nature which needs interpretation, this substan- which would deal with a substantial question of law of great importance affecting the state legislation, or the this administrative and this administrative policy. If that is so, the state Honorable High Court generally grants the certification for preferring an appeal before the Honorable Supreme Court. If you are invoking Article 132, directly the appeal is available before the Honorable Supreme Court. But in another cases which are covered under Article 133 as well as 134, not in every cases the High Court would be giving the certificate and directly you can go for an appeal. You are supposed to seek leave in these two matters. If whenever a list has been decided by the Honorable High Court and you want to approach the Honorable Supreme Court, under Article 133 or 134, you are required to have you are required to seek leave before your appeal gets admitted before the Honorable Supreme Court. There are other powers of review also available to the Honorable Supreme Court. And one must also keep in mind how the presidential value of the Supreme Court is as good as law of the land. That comes from Article 141. Whenever there is a pronouncement of any legal issue by the Honorable Supreme Court, it becomes a binding precedent for all the subordinate courts. It becomes the law of the land till the concerned legislature, be it the parliament or the concerned state assembly, come up with a new law to uh, deal with that particular precedent. Now, coming back to state judiciary, Article 226. I'll be just flip flopping if it is convenient to all. Ms. Kaur, is it fine?
Yes, sir, it is.
Right. See, now High Court under Article 226, as I discussed earlier, has wide powers to to issue various kinds of writs. The detail, when you read this text of this article, uh, most of the things are clear. But many a times people mix with uh, the powers of the Honorable High Court under Article 226 with Article 227. Now, what is the powers of every High Court under Article 227? Let us just read the title only because of the constraint of time. Power of superintendence over all courts by the High Court. One must always keep in mind Article 226 of the Constitution is an original jurisdiction, original extraordinary inherent jurisdiction vested in a High Court, wherein it can deal with any issue subject to certain restrictions or the reasonable restrictions which have been self-imposed by the Honorable High Court. Now, Article 227 is giving the supervisory jurisdiction to the High Courts to deal with the decisions of the subordinate courts, for which one of the subordinates would in future would be some of them who are right now in the audience. Then Article 228 under which empowers the High Court to transfer any case from one court to another which is coming within its jurisdiction. And then now chapter 6 in this part, article 233 concerning district subordinate courts. You must be aware under which provision you are if you are applying for a civil judge, you must be aware as to from by following which procedure your superiors who would be in the cadre of district judge are being appointed, and where is the source coming. Now article 233 provides for appointment of district judge. It gives the entire procedure. If you must even see how they are being appointed, though appointed by the governor, but in consultation with the High Court. Now, your appointment, Article 234, recruitment of persons other than district judge to the judicial services. This is where the Honorable High Court, as per I would say the Gujarat Judicial Services rules, comes into picture by way of with the aid of this article 234 as well as 235. I'll just read it hurriedly. Appointment of persons other than district judges to the judicial services of a state shall be made by the governor of the state in accordance with rules made by him in that behalf after consultation with the state public service commission and with the high court exercising jurisdiction in relation to such state. In the in the state of Gujarat, the uh, consultation process with state public service commission is not there. Directly the honorable high court, after conducting the entire exercise, would be recommending it to the state government, and the state government would be then appointing. Article 235 control. See the control, how the there, if you are aware, there are civil manuals and criminal manuals issued by the High Court of Gujarat, which has been widely circulated in most of the courts, handily available. Though this Article 235 of the Constitution gives the, I would say, advisory jurisdiction to the Honorable High Court to advise the subordinate judiciary as to how they are supposed to manage their judicial as well as administrative functions. I'll just go through it fast. The control over district courts and courts subordinate thereto, including the posting and promotion of and grant of leave to persons belonging to judicial services of a state and holding any post inferior to the post of district judge, shall be vested in the High Court, but nothing in this article shall be construed as taking away from any such person any right of appeal which he may have under the law regulating the conditions of his service, or as authorizing the High Court to deal with otherwise than in accordance with conditions of his services prescribed under such law. Now, as far as state judiciary, subordinate judiciary, and union judiciary, I have mostly tried to just give you an outline as to how, at which places the provisions are provided in the Constitution. Now, I'll be even sharing this PPT with Ms. Kaur in a while. Then, if we go further, most of the provisions of the Constitution are in respect of how the laws are to be made and how the parliament and the state legislature and the local authorities are supposed to function. So I at this juncture, I'll not be dealing with those. But before going further, I'll just bring to the notice of everyone that one right which was available to the individuals prior to 1979, that was right to property, which was recognized as a fundamental right at that point of time, has been shifted now as a constitutional right under Article 300A. This is where whenever a person's right to safeguard his property is concerned, that is backed by Article 300A. Whenever a judge is supposed to deal with a property matter, impliedly Constitution's Article 300A would come into picture. So keeping in mind those perspective, you would be deciding the list. Here also there are certain restrictions which are being provided by various state as well as central legislations. So now then I'll be directly going to some emergency provisions which have been in certain examinations have time and again been asked, and they that is in part 18, mostly article 352, when the proclamation of emergency can be made by the president and what is the procedure thereof. Article 353 deals with what would be the effect of proclamation of the emergency. Then article 356, under which circumstances, one must know as to under which circumstances the provisions of emergency could be invoked in a particular state and how it is to be done. Article 356, provision in case of failure of constitutional machinery in states. You must understand as to, these are quite heavy words. One and cannot be, I would say, exploited merely at the political whims of be it a union government or a particular state government. That is why this provision, it has also undergone various amendments and certain criticism as well as certain scrutiny. I would just read it hurriedly. Under which circumstances a president can invoke this particular clause. If the president, on receipt of a report from the governor of a state or otherwise, is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the constitution, the president may by proclamation do so and so and so and so. So one must always keep in mind. Then I'll just skip all those articles now and come to Schedule 7 of the Constitution. One of the schedules of out of 12 which have been with the aid of Article 246, this entire 7 schedule has been prescribed. One must always keep in mind that what is the jurisdiction for wasted in the union and the state for this making a particular enactment for their respective individuals. For that, let us go to Article 246. Subject matter of law made by Parliament and by the legislature of state. One must always keep in mind, whenever a law is promulgated, the issue of whether the state legislature or the central legislature, whether they are competent to make the law or not, is to be determined by invoking or by the test which is provided under Article 246 read with 7th schedule. That is why this article is also very important when you are dealing with an issue concerning competency of the state legislature or the central legislature in making a law. That is why before that, I just want to come back to Article 13, one of the pivotal articles based on which the courts are functioning. Whenever legality and validity of a particular statute is under question. Article 13 goes like this: laws inconsistent with or in derogation of the fundamental rights. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with provisions of this part, shall, to the extent of such inconsistency, be void. State shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. In this article, unless the context otherwise requires, please see the wordings of Article 13, which say, which I would say define, not define, but proposes as to what are the laws covered under Article 13. It's an inclusive definition, a sort of definition. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. And what does force of law mean? Clause B includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any law thereof may not be then in operation either at all or in particular areas. Now coming back to Article 246. Subject matter of laws made by Parliament and by legislature. Here also one must see laws would mean it has to be in conformity with the Article 13 test which is provided in the Article 13. Notwithstanding anything in clause 2 and clause 3, Parliament has exclusive power to make laws in respect of any of the matters enumerated in list 1 in the 7th schedule in this constitution, referred to as the Union List. Clause 2. Notwithstanding anything in clause 3, Parliament, and subject to clause 1, the legislature of any state also have power to make laws with respect to any of the matters enumerated in list 3 in 7th schedule in constitution, referred to in as concurrent list, subject to so and so. Now let us see the 7th schedule. You would find the list 1 consists of Union List. This is where one must always keep in mind as to what are the powers of central legislation, that is the Parliament, and what is the domain of state legislations, legislature, that is in number this list 2. Just for an example, one must always see the very first entries: defense of India and every part thereof, including preparation for defense and all such acts as may be conducive in times of war to its prosecution after its termination to effective demobilization. And as against this, the first entry in list 2, public order, but not including the use of naval, military, or air force or any other armed force of the Union or of any other force subject to the control of the Union or any contingent or unit thereof in aid of civil power. Now, these are well defined as to what are the in which areas of law Union can enact the laws and in which field these states can enact. Maximum confusion which is generally created is in respect of list 3, the concurrent list. Most of the times the courts are made to test that whenever this constitutional competency of the legislature is under challenge, this these entries, these articles would have to the tests which are prescribed under for determining the capacity, I would say, the uh, jurisdiction of that particular lawmaking agency would be governed. Right? Then there are other schedules also. One, schedule 9, which is at one which was criticized at once upon a time, and because of which Keshavanand Bharti came, is also there. You can, for a language, 8 schedule, and so on and so forth. If you all are preparing for this particular exam, then I would just say you should be reading the index of the constitution, by which you would be uh, uh, having a glimpse of where which provision is lying. As far as the details, or the, I would say, the doctrines or the philosophy part is concerned, this may not be, you may not be go into that at this stage, because I believe it's a very short period is only left for you all. Now, coming to the second issue, sorry, I would say the second topic which was given to me was pertaining to legal maxims. I'll be sharing this slide with the coordinator. Just a minute. Please bear with me. I'm not so accustomed with this. Okay, wait. Now, the second topic which was given to me pertaining to legal maxims. I have sorted out certain maxims. Take a minute. Which may be helpful for your examination. This is okay. Is the screen still being shared?
Yes, sir.
Yes. Okay. Now, the I'll be even taking questions from you all regarding constitution. But before that, let me finish this topic, and then, okay, is it fine? No.
Yes, sir. Yes, sir. It is fine.
Okay. Now, one of the first maxim which I would like to harp upon is res ipsa loquitur. You would find it time and again in various judgments, this particular maxim being used, which means that it's an English translation. The things speak for itself. I have given an example that if you are going to a particular store with, sorry, not this. A patient undergoes surgery and later discovers a surgical sponge was left inside their body. The hospital is presumed negligent even without direct evidence, because such accidents don't happen without someone's fault. Things speak for itself. Audi alter partem, one of the most I I would say celebrated maxim, which has its genesis from this Article 19 as well as Article 14 also, that no one can be condemned unheard. This translation may be plus or minus, but audi alter partem would mean no person shall be condemned unheard. Mostly in judicial proceedings, there the this maxim, or the this principle of natural justice has to be kept in mind by the judicial officers, that every person or every litigant who is before them must be given a reasonable opportunity of hearing, and then comes the other maxim, nemo judex in causa sua. No one is a judge in his own cause. This is when mostly this maxim is applied against the state agencies when the statute provide them with them. When I say them, means certain officers of a particular class, that they have been conferred with certain powers to adjudicate, wherein their own office or their own interest is involved. Whenever such is an allegation, the writ of certiorari is also available to the person who is claiming that. Then the criminal and the civil jurisprudence is dependent on this maxim. Ignoratia juris non excusat. Ignorance of law is no excuse. One cannot claim that he was unaware of a law once it has been promulgated. I have given examples also. If I'll request to read it. Then actus reus non facet reum nisi mens rea mensit rea. The act does not make a person guilty unless the mind is also guilty. This is based on this maxim, the criminal jurisprudence is functioning. First of all, an act must be an offense, and there must be a criminal intent to do that particular act with a conscious mind that the result would be an offense. That is why this particular maxim has been mostly widely used in criminal jurisprudence. This is also connected with criminal jurisprudence only. Consensus ad ideum, meeting of minds. The concept or the under the Indian Evidence Act, the conspiracy theory or the abatement theory are all based on the this maxim. Pacta sunt servanda. The agreement must be kept. This would be the doctrine of this maxim would be helpful for determining the contractual disputes, or the whenever there is an issue raised pertaining to dispute, say breach of contract, then this is the maxim which the doctrine, I would not use the word maxim, but the doctrine which would help you in determining it. Now everyone must be knowing it who has cleared the LLB. Ubi just ibi remedium. Where there is a right, there is a remedy. The next one is connected. This one. Damnum sine injuria, damage without injury. One must understand the distinction between these two maxims. When I have tried to give an example, this illustration, saying that a woman is denied her rightful salary, she can approach the court for compensation. There is an injury. She has been deprived of her salary. She can approach the court as she is having a legal remedy. Now, comparing it with this, damage without injury, damnum sine injuria. A new shop opens next to an old one and draws away customers. The old shop suffers loss but cannot sue as there is no legal right violate. I hope this should explain or rather make it clear. Then voluntary non-fit injuria. No injury is done to a willing person. This is where the consent, the concept of consent has evolved. Just for an example, a spectator attends a cricket match and is hit by a ball in the stand. Since they willingly accepted the risk by attending the match, the organizers are not liable for the injury, provided reasonable safety measures were in place. Now, I would not treat this as a maxim, but it's a doctrine of res judicata which restricts the courts from uh, restrict the parties from re-agitating the very same issue before a particular court. That is why this is based on a public policy that litigation must come to an end at a before a particular forum. That is why this particular this example, a man sues a company for breach of contract and loses. He cannot file another case on the same issue as the matter has already been decided. Caveat emptor also, everyone knows that buyers beware. No need to further explain it. Nullum crium, nulla poena sine lega. No crime, no punishment without law. One has to understand. I did read Article 20, if you recollect. This is also saying the very same thing. The day on which an act was done, if it is not an offense, then it is not liable to be punished. Now, fiat justitia ruat caelum. Let justice be done, though the heavens fall. This is generally for the judges who would be dealing with the legal issues, because many a times certain perspective which is going on in the common man's mind, that they are not getting justice. A judge should always keep this phenomena in his mind. He is there to do justice in accordance with law by interpreting the law, no matter what the end result is. Thank you. Now,
Uh, Thank you so much, sir, for this wonderful session. Now we open the floor for question and answers. Whosoever ever have any questions, you can raise your hands or write your questions in the chat box.
generally we have a saying that when nobody asks a question, that means either they have understood everything, or I am unable to, or the orator has failed to explain as to what he attempted to convey. I don't know what is the situation right now.
So there's a question which has been frequently asked in exams.
See, I had appeared only once at relevant point of time, so and I have lost track of it. But as far as constitution and these are concerned, I would suggest that focus on jurisdiction aspect, jurisdictions of different courts. Focus on fundamental rights, fundamental duties. The part 3 and part 4. 4A is also there. Sorry, part 3. Then this emergency provisions have been is also needed to be kept in mind. Then as this schedule list, article 246 and all, mostly what I have heard is it is concerning jurisdiction, fundamental rights, fundamental duties, and the first three part of the constitution, mostly first three parts.
So there's another question. Sir, ये legal maxim में से ही questions आएंगे.
ये देखिए, मैं क्वेश्चन पेपर अभी सेट तो करने वाला हूं नहीं, तो इट इज, देखिए कॉमनली जो यूज होते हैं वो आप देख लीजिए, क्योंकि दीज आर आई हैव ट्राइड टू फैच द मोस्ट कॉमनली यूज्ड मैगजीम्स विच आर जनरली, इफ यू वुड ओपन अ लॉ रिपोर्टर, यू कैन फाइंड आइदर ऑफ द इन ये 15 में से 10 तो आपको एक एडिशन में मिल ही जाएगा कहीं ना कहीं पे. So these are the most commonly used magazines. So I don't
Sir,
know about what would the High Court ask.
can you please explain Article 142A?
Article 142A. That's good. Article 142A. Sorry, probably I'm having a book which is after Article 142, enforcement of decree and orders of Supreme Court as discovery, etc. Then Article 143 is there. I cannot find it in my book at least. 142 or something else. They may have
Sir, here
misquoted
it is written 142A only.
it. I don't have in my constitution. They may be
We
having a
can
different
take
constitution.
another question, sir. Is
Very
the Honorable Supreme Court has original criminal jurisdiction?
original criminal jurisdiction is not there, but I did point out regarding that original jurisdiction under Article 32. Whenever criminal jurisdiction, one must understand that Supreme Court would not be directly punishing someone except for contempt. There is Supreme Court being a court of record has independent powers of contempt under Constitution as well as the under the Contempt of Courts Act. Other than that, I had even dealt with the very first article, this Article 131, which has which deals with original jurisdiction of Supreme Court. Whenever there is a dispute between us, between two states or the union and the state, if you were aware, the Kaveri River water issue, which is going on between the southern states, there are other issues also wherein center and state are not, like the one which was filed by Kerala. They had Kerala state had filed a suit before the Honorable Supreme Court directly against the central government for not releasing certain revenues or just 2 or 3 years back. There, the Honorable Supreme Court is having original jurisdiction, which you can find in Article 131. Next.
So there's no other question. Thank you so much, sir, for this
It's a
wonderful.
pleasure.
On behalf of organizing committee, I extend a warm welcome, deepest gratitude to you, not only for accepting our invitation, but also for this wonderful session. And I would also like to express my deepest gratitude towards Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, and Patron of Sambhav Initiative, Mr. M.R. Shah, sir, former judges of Supreme Court of India, under whose vision and guidance today we were able to conduct 10 days online national capacity building program for civil judge examination for Gujrat State Judiciary. And thanks to all the participants for joining us this evening. Thank you so much, sir, for this wonderful session.
I
Uh,
am honored, and my best wishes for all the participants whom I believe would be clearing this exam with wonderful colors. My best wishes to them.
Thank you so much, sir. Looking forward to host you all tomorrow, as there are two sessions scheduled for tomorrow. First session will be at 10:30 a.m. and second session is scheduled at 4 p.m. So participants kindly join by tomorrow. Thank you so much,
Thank you
sir.
very much, Arvind sir, for joining today.
Thank you, sir. Thank you for.
G. And please send a PPT with me so we can share with
Uh,
participant in group, sir.
Very well. I'll be just sending it. The
Yes,
last
yes, sir.
number from which I got a call, I'll be sending it.
Jayant Agrawal, sir. Yes, right, sir. Right.
Very, very.
Yes. Thank you.